Hi, sir.
Good morning.
Hi, you have a tutorial after this, right? I think I know your own tutorial. You have one after this.
Yes, there's another one at noon.
Okay, that's the one I'm in, so I'm gonna wait.
Okay.
All right, see ya.
All right. Good morning, everyone,
Good
and
morning.
welcome. Let's see. Last couple of stragglers. All right. So the question for today that I asked you guys to prepare is on e-learning, and we're going to get to that in a minute. But I want to start by checking in and um, finding out what you feel like you learned last week and anything that might be unclear or confusing for you. So what did we learn last week? And you can always speak up, Christy.
Just to be clear, right? We still on the duty of care. That's the topic, right?
I'm sorry, say that again, Ariel.
The duty of care. That's the topic that we're dealing with.
That was last week, yes. So
Okay.
what did we learn last week?
Okay. So my first point is that the duty of care must be first established. It must be first established that the defendant owed a duty of care in relation to the claimant and the type of damage suffered. So it must be identified. The type of damage suffered and that they did owe a duty of care to the claimant.
Great. Yeah, that's exactly right. Okay. And we learned about the tests that are associated with determining whether the duty of care exists, right? We learned about sort of the evolution of the doctrine over the course of more or less the last century. Um, so, yeah, great. Exactly right. Okay. Um, is there anything from last week that you're not comfortable with that you don't feel like you have clarity on? No, everything's clear. Okay, great. Moving on then. So today's tutorial is reaching back 2 weeks. So given that we didn't do anything substantive in the first 2 weeks of tutorial, right? The first week because we were just getting to know one another, and the second week because of the scheduling issues that caused tutorials to be canceled. This is how we're going to be doing things through the course of the semester. So we're going to meet in a tutorial. We're going to check in on the prior week to make sure that we understand it. And then we're going to spend some time doing a little bit of a deeper dive on the material from 2 weeks prior. So that's how this course is going to be structured in the tutorial side. Okay, there will be exceptions, but that's going to be sort of the broad strokes of how things work. Okay, so with that in mind, let's move on to the question that you were asked to prepare. And that question is that contract and criminal liability sufficiently deter negligent conduct without the need for independent causes of action in tort. Okay, you were asked to prepare arguments for both sides. And if I have to, I will call on people at random and just sort of make you participate, but I prefer not to do that if I can avoid it. So is there anybody who wants to offer up what they were able to come up with on the side of the proposition, right? And so this is the harder side. This is the side that's pushing for a move away from the status quo. It's trickier, but anybody want to offer up what they were able to come up with on that?
Just to be clear, you mean what you could come up with in favor of this statement?
Yes.
I guess that some could argue that since tort, the remedies are primarily paid by insurance companies, it might not be the best deterrent for negligent behavior if it's just going to get paid off by insurance.
Right. So, I think that's absolutely a valid argument, right? When we look at modern tort, right, as I pointed out in the lecture yesterday, the person who is actually responsible in a lot of tort cases is the insurer. And we rely on this sort of indirect deterrent effect where a tortfeasor, right, someone who commits a lot of torts, can't get insurance. And so because they don't have that insurance, they behave with a greater duty of care than they had before. So I think Shanice is absolutely right that that's a troubling, that's a really Rube Goldberg sort of incentive structure, right? We're pushing on this thing in order to create a change over here that then is going to induce the behavior that we want in this third person, right? So there's a lot of moving parts here that makes it very complicated. I think Shanice has offered a really helpful point. So what do you guys think about it?
Sir, hi, good morning.
Good morning. Go ahead.
I was wondering, would it have anything to do with the jurisdiction of where you took the insurance? So for example, you said you were from Alabama to Barbados. Mm-hmm. You took out your insurance in Alabama, correct?
Yes.
Right.
Well, so there are ways to contract around that, right? There are choice of law provisions, but absolutely the insurance referred to an American jurisdiction. It may not have been Alabama.
Right. Okay.
So, but go ahead with your point. I'm sorry, I didn't.
That's fine. That's fine. The point I was trying to get at is, let's say that it happened in Barbados at the last stage of a movement. Mm-hmm. Would your insurance company that you took out the insurance with in Alabama still be liable for something that has happened that in Barbados, which is totally out of their jurisdiction, totally out of their hands? In fact, they got the shipment to where you insured to get it to, which is to Barbados. Who's to say it was to come to the address that you had it to? Who's to say that they were responsible after it reached Barbados? So yeah. Will those jurisdictions and those insurance companies be looking at those clauses if they wanted to escape from such commitment to owe you a duty of care?
I mean, I think you're absolutely right that those are things that could arise. I think that in this specific circumstance and in most, modern circumstances, so for example, right, with my particular move, I paid for a door-to-door move. So the movers walked in. I had packed nothing. I think they were a little surprised by that. They packed up my whole household, put it on the truck, transported it to the port, transferred it to the ship. Ship brought it to Bridgetown. Then it was transferred into the hands of the customs broker, and it was brought all the way into my house and unpacked, unwrapped. So that, now I paid for that. I paid quite a bit for that. Not worth going into the details, but yeah. So, but like if I had paid for what's called a port to port move, okay, it would have been my responsibility to get my household goods to the port of Mobile, and then again to get them from the port of Bridgetown to my house, right? I could have, and absolutely the insurer would have been, had I done that, the insurer would have been arguing that any breakage took place prior to the goods arriving at the port, because that's how insurance companies are, right? If they have an argument for why they don't have to pay, they will always do it, right? So I think you're right that if there was a way out, the insurer would be looking for it. And I think that, you know, to sort of bring it back to the question for the tutorial, right? That's another reason why I think we should be willing to be critical and suspicious of modern tort law, because what happens is we've created a system where tortfeasors can contract themselves into a place where they are not liable for their own malfeasance, right? Or even, you know, or even where they can contract out of the insurer being liable for their malfeasance, right? So we can, so I think that these are good reasons for us to ask, is the modern tort system really working as intended? Okay, what other thoughts do we have on this?
Good morning, sir. I said it could be argued that
Good morning. Go ahead.
because criminal law has such a high standard that maybe that's enough to deter people from not committing crimes. So maybe that's why tort might not be necessary, because your standard might be high enough.
So what do you mean by standard?
It's really hard to, well, you have to prove it beyond reasonable doubt that the person committed the crime. So wait.
And so that's going to be a deterrent to criminal behavior?
Wait, oh shit. I think I mixed up myself, so never mind.
Well, so I think you've raised a really important point, right? But I think that maybe the logic is flipped from what you said. Because you're absolutely right that to convict someone of a crime, the state has to prove their case beyond a reasonable doubt, right? And in a torts case, right, whether it's an auto wreck or somebody got run over by a church bell or whatever, right? The standard is the balance of probabilities. Okay, the balance of probabilities. And what that means, right, you may have heard it referred to as more likely than not that the defendant behaved negligently. You may have heard it described as a 51% probability. Okay, and it could even be less than that. The way that I used to describe it to my clients was the plaintiff has to prove that the likelihood of negligence is a coin flip plus something. And that something can be as small as anything once you get the coin flip, but you got to have the coin flip plus something. Okay. So what winds up happening, right, is you have these cases, and we talked about this. I know I've talked about it at some point, but you know, with 7 tutorials a week, I'm never clear on what I've said to whom. But at some point, I discussed that that there are lots of situations where both criminal liability and tort liability can be imposed, right? But in order to impose criminal liability, we have to meet this really high standard, this beyond a reasonable doubt standard, lower balance of probability standard. And so what happens is all the cases where the probability of misconduct is greater than the balance of probabilities, but less than beyond reasonable doubt, if we move tort into the criminal sphere, all of those cases cannot be deterred, right? So the standard of proof in the criminal sphere means that less conduct gets punished, right? Less misconduct gets corrected, fewer people are made whole. And that is a perfectly acceptable trade-off to help you understand. All right. So, all right, so this is the whiteboard.
Sir,
What? Go ahead. Go ahead.
Go over that. My internet was in and out, so I didn't hear that part. You were speaking of.
That's what I'm doing now. That's what I'm doing now. Okay. So, all right. So, please assume that this was drawn by someone who can actually draw a normal distribution. So, in order to prove tort, right, we have to prove that it is more likely than not, the 50% point. Let me change colors so that you can see this. All right. So this is the tort liability cutoff. Okay, and I'll label these axes, right? Probability of negligence, misconduct, okay, and I'll put that up, and then we'll label this axis. Well, no, we won't label that axis. This is just the number of cases, is the vertical axis. Anything on this side of the red line is there's no liability. Okay. Anything on the right side, there is liability in the event of a tort, right? Of a tort case. And then we have this green line. Wait, oh, no. This. Go away. I hate. All right, there we go. That'll work, whatever. Okay. Over here, So this is the criminal liability cutoff, right? So all of these cases between the two red lines don't get corrected. There's no redress for those cases. Okay. If we move tort into the criminal sphere. All right. So does that, for those of who were confused about this, does that help make it clearer? Yes, no, maybe. Okay. Okay, good. All right. So what other thoughts do we have on this, right? What other ideas do we have?
Sir, did we finish the Donahue versus Stevenson case? Because I think the last time when we were finally discussing it, how the law of torts was applied in negligence, I think we came to end. I could be wrong, but I think you were trying to explain how that case.
Well, I don't think that the Donahue case is terribly important.
Okay.
I think that it is a very important first step, but the doctrine has evolved. And if you are relying on Donahue versus Stevenson in the year of our Lord 2021, you are going to be laughed out of court. You need it. You need to be relying on recent relevant precedents. So that I certainly, we mention it, we discuss it briefly, and then we move on because it is no longer good law. Okay. The standard for whether a duty of care exists is no longer expressed by the neighbor principle of Donahue. It is expressed by the standards in Robinson and Poolborough Council, and to a lesser extent Caparo, but the whole point of Robinson is that Caparo was being applied incorrectly in lower courts. Okay. So, okay, so what else do you guys have?
Sir, can we talk on the against point, the against the statement?
Yeah. No, yes, yeah. Absolutely. No. If that's where you're ready to go, then we're ready to go there. So
Okay.
the whole point of starting with 4 is to start the conversation, but then we can take it where it goes. So.
Okay. I just mentioned the fact that contract requires a pre-existing relationship where it's hard you don't, for if the person causes harm to you, then they will be liable. You don't have to have the pre-existing relationship if they owe the duty of care. And in criminal law, it's not focused on helping the person, restore to the original position they were in, but tort allows for that to help the person. It's more about helping the individual.
Yep. So these are two really important points, right? Is that contract liability presumes some sort of pre-existing relationship before the harm. And so to import tort law into contracts, we would have to sort of create these relationships, right? We'd have to say, okay, by driving on the road, you have agreed with every other driver that you will keep a proper lookout, right? Those sorts of circumlocutions, right? Ways of talking around the problem. And the other thing is absolutely correct, right? That with a criminal case, the victim, right, the injured party, is to some extent irrelevant, right? They matter. They're the reason for the case, but the case is brought to vindicate the state's power, right? The state's ability to delineate the boundaries of acceptable conduct. It's not brought to make whole the injured party, right? So you're absolutely right, Shasia. Those are two really great points. What do those bring up any thoughts for you guys?
Yeah, I just want to comment that I have done some reading, and this what the chief medical officer.
Dangerous, always dangerous to do the reading. Go ahead. I'm sorry.
In the UK, a little while ago, when he was basically evaluating the medical negligence cases in the NHS and how it was basically done through tort law, and though tort law is a way for the victims to get compensated, a problem was that in their system, it was too long and complicated, and they weren't really getting money that they saw as worth the injury, basically. So it was too long, too complicated, and too expensive. So those were problems that he pointed out with people who went through tort.
Yeah, I think that's, these are legitimate issues, right? That the tort system takes time to work itself through. And sometimes it can blow up in your face, right? Because there may not be any duty of care. I'll tell you guys a story from a case I lost. God, it's been almost 10 years now. I argued this case in January of 2012. The issue in the case was that this woman had checked herself into a psychiatric hospital because she was suicidal. And for various reasons that are not really germane to the outcome, she was not kept on watch, and a nurse came in and she was attempting to kill herself, and she had managed to stop her breathing, and they did not perform CPR for reasons that, again, are not really germane. And the question was, what duty did they owe her? Right? And without sort of getting in the weeds of the case that isn't really relevant for you guys because it's an American case, the long and the short of it is that because she checked herself into hospital, the hospital owed her no duty to prevent her from harming herself. Right? This woman died in 2008. I lost the case at the Court of Appeals in June of 2012 was when the opinion came down. So the system can drag on for quite some time, and then you still get nothing. So so Shanice is absolutely right that that the wheels of justice grind slow, and they don't necessarily grind terribly fine. Sadia, I agree that it was extremely ridiculous. I was surprised by the ruling because I was absolutely convinced that my argument would carry the day. If you are interested, you are not required to read this, but if you are interested, the case is Shelton versus Arkansas Department of Human Services, and it was at the 8th Circuit Court of Appeals in 2012. So absolutely not required, but if you're interested in the logic the court used to dispose of the case, you're more than welcome to look it up. Barry, you've had your hand up. Go ahead.
Yeah, it brought me to the question, how does the court, Barbados, Caribbean, America, wherever, how do they decide when cases are actually called? Because like you said, it's almost 10 years, she could have died during that time, the case would have become nothing would have come of the case. But like how the courts, like, I was reading the paper yesterday and there's a case going on that was from 2006. A case involving a young lady who was sexually assaulted. She was 13. She was 13 then, and now she's like almost in her 30s, and she doesn't seem as interested in the case. So how do they decide the cases?
Well, these are questions of civil procedure, and give me 1 second because folks are asking in the chat to type the name of the Shelton case. So let me do that, and then we'll give you my attention. I don't have the citation off the top of my head, but if you go on to Google Scholar, the case name should give you the opinion. So it's Shelton versus Arkansas Department of Human Services, 8th Circuit 2012. Okay, so Barry asks, how do cases get called? And I can't speak to Caribbean civil procedure because I'm not an expert in it, and this is not a civil procedure class. But in federal court in the United States, there is actually a rule of civil procedure that requires that every case receive a scheduling order. And what that does is that imposes deadlines for every phase of the litigation and sets a trial date. And you can alter that scheduling order, and it is not uncommon for trial dates in particular to be moved out and for deadlines to get extended, right? Things of that nature. But once you have filed your case and the defendant has been served, within a month or two, you have a trial date for your case. You'll almost never proceed to trial on that date, but you have one. But if you lose your case, right? So this Shelton case was resolved on a motion to dismiss, which is a very early. It's basically a demurrer, right? A non-suit motion. And then we appealed it, and the court appeals took their time with it, so it sat for quite some time. For reasons that are not worth going into, the malpractice claim was not available. Again, I don't want to get in the weeds of this case because it's not a case that's relevant for you guys. But you're absolutely right that in Barbados or Trinidad or St. Vincent, right, you would absolutely be asking questions about malpractice under the facts that I've given you, okay, under the facts of the Shelton case. FISA, it is a jurisdictional issue, and it's specific to an issue in American law, and so we're not going to be spending a lot of time. We're not going to be spending time on it. So got a private message that points out that both contract and criminal cases are a little more straightforward than tort cases, because there is no question in contracts or crimes of whether the defendant had a duty. The only question is whether the duty was breached, right? Because everybody has a duty not to commit crimes. If you are a party to a contract, you obviously have a duty to perform. But with torts, as we discussed last week, and as we're discussing right now, right, you do have to determine whether there's a duty at all before you can even ask the question of whether it's breached, right? And the other piece of this, which we have not discussed in this class, is that even after you show that a duty and breach occurred, right, that a duty existed, that a breach occurred, you still have to show causation, right? In crime, in criminal cases, in contract cases, you don't have to show that that the breach of duty caused the harm, right? That piece of it is presumed. But in tort, you absolutely do. So these are so I think these are really helpful things to keep in mind. I'm not going to call out the student who messaged me that privately, but you should definitely feel free to put your comments in the chat for everyone rather than just for me. So because you're making good comments, and the rest of your classmates should be able to benefit from your erudition. So all right, so what other questions do you guys have before we wrap things up? I don't have a problem with tutorials running a little short if we've covered everything that I sort of wanted to draw out. So what questions do you guys have? Can be about the tutorial, can be about stuff we've covered in the course. This is your opportunity. Nothing? Feeling
Sir, did you find out? I think I vaguely remember at the beginning of the course. I think you were one of the first lecturers to have class. You were going to confirm what our exams and midterms are going to form. Has that been confirmed?
Yep. We still don't have a final approval from the central administration on that. So again, the best advice I can give you at this point is to look at the course outline in the faculty handbook on the Cave Hill website. What I proposed to the administration for online assessments was not a massive departure from that. So that's the best I've got for you, unfortunately. So I have a question here privately. Can you explain the tutorial question a bit more? Persons were merely comparing the types of law, but I didn't understand that. And I think that's I think that's helpful for us, because it there are assumptions in the question that aren't necessarily apparent. And so if you're not understanding the question, it's okay to ask for those things to be unpacked. The question is implying a hypothetical that we are going to wipe out tort law in its entirety, but does not occupy a unique space. It does not resolve a unique set of disputes. Everything that tort law resolves can be handled either through contract or through criminal law. That's the hypothetical that the question poses, and you are being asked to offer arguments for one side or the other, or both is really what you were asked to do. So does that, again, if you message me privately here on Zoom, I'm not going to out you, but to the person who asked that question, do you feel better about understanding the conversation? Great. Okay. What other questions do you have? Nothing else? Okay. Questions going once? Going twice? All right, well then we're gonna wrap things up, and I will see you guys on Monday, and take care. Bye.